despite that, he invited Jay back over with the promise that he was going to do something he never done before. Ladies and gentlemen, you will see how the police traced Jay to that apartment. You will see that when Jay gets there, he lets Timothy know he's there. But right before Jay gets to his apartment, when he's headed over, right before he gets there, just a mere minutes, Timothy searches how long does it take to strangle someone. The evidence will further show that Jay never left that apartment on his own. Ladies and gentlemen, the detectives will tell you how they discovered Timothy was a suspect. They will tell you what he did the day after, or the same day after. We're going to walk through all the evidence. And they're going to tell you how we know that Jay is no longer alive. In preparing to speak to you all today, I was looking at some quotes and reading some things like I do, and I saw something and it said, "The rest is silence." Because I was thinking, what makes up a life? Jay's death is in silence. No more financial transactions. No more social media posts. No more contacts with his mother, not checking up on her, not on her birthday. No more contacts with his dogs. No more anything. The plans for grad school, to move, the dreams. All proof that Jay is no longer with us. In that proof, that is how we know that we must seek justice. And at the conclusion of the evidence, I'm going to come back before you. And I'm going to ask that you provide the only verdict that justice will demand. And it's going to be guilty. Thank you.
All right, everybody good on the jury? Officer, back, I want to see if anybody out there this started the show that would like to come in. I'm going to ask you, well, there's anybody coming and going on that come, then we having breaks. But if there's anybody out there that wants to come in now or leave now, they can do so. And you wish to make an opening statement this time, Mr. Hoban? Go ahead and be getting warmed up anyway. Be tuning up, okay? Just see if there's anybody there. All right. Once you're out, you're out. Once you're in, you're in.
I proceed, Your Honor.
Give me 1 minute. Go ahead. You done your...
Thank you, Your Honor. Ladies and gentlemen, first of all, I want to tell each one of y'all, some of y'all sitting on this jury today, just one more answer to a question from the judge and counsel still be in Hattiesburg with the family. One question it would have been easy for each one of y'all, at least some of them, have answered the question a different way, and you wouldn't be in Austin, Mississippi. And I appreciate the fact that each one of y'all found your way to Austin and willing to do your civic duty for the citizens of the state of Mississippi and the people of Austin, and for the parties of the bill. I want to talk to you a little bit about the counsel opposite talked about as far as what they anticipate showing you in their case. First of all, I recall Crickmore using an old, what we call common law term of embezzlement. That is, tricking somebody to come over, or a child, normally it's in the case of children at a park or something, get a child, and you don't have to take them anywhere else, you take with them at that point in time, and technically, the heist is the kidnapping. Now, I noticed that they didn't mention anything about the kidnapping aspect of it. They've got to prove that, ladies and gentlemen, they have got to prove that. That means that during the course of what they claim they're going to put into evidence, certain messages, conversations between Jay Lee and my client, they got to establish that happened. Because if that didn't happen, the rest of their case goes like a house of cards. You're going to, assuming the court allows any of this messaging and social media evidence in before you, you're going to hear that approximately 2:03, 2:04 in the morning, Jay Lee reached out, assuming it comes in, evidence, to this Herrington. And I implore you to find anything in what they provided to us that supports the proposition that there was any threat or anything in those messages that my client threatened him in any way with. And I don't doubt, ladies and gentlemen, you're going to hear evidence about how David's mother loved him. I'm not saying he was a bad person, certainly not. The court's going to instruct you at the conclusion of this case that you cannot allow sympathy for a mother come into play here. You consider what she says as evidence. But y'all have got to decide in this case on facts. And what you're going to hear is nothing about a threat in any shape, form, or fashion from my client. And you're not going to hear that he searched anything about strangling anybody. That he gathered any information for that purpose. Now, I'm going to say this. You tell by the board hour yesterday, these are touchy subjects for everybody to get involved in. It doesn't matter whether or not it's heterosexual conduct or otherwise. Talking about creases of the night, late hours, about two consenting adults, what they're doing late at night, it's just touchy. Hard to board hour, hard to talk to George about it. People that you've never met before. But I say that because nothing against the young man, but there's going to be a lot of information I think you're going to hear about Mr. Lee's conduct prior to this night and the manner in which he conducted himself. I'm not passing judgment on the young man. Those are facts. You cannot abandon your sense of responsibility. And that's what they're going to ask you to do. Worry about the facts. Worry about compassion. Worry about sympathy. Things that occurred in his life, it was not unusual for him to be going out in the middle of the night. I think the evidence is going to show. I didn't make these things up. It's going to be stuff that the state provided to us. Okay? The way it is. He did go over, according to what I anticipate the state is going to present to you, and again, assuming that the judge allows that evidence to come in, you did go to my client's apartment. It's going to be their theory. But it was completely unannounced. No evidence otherwise. Not that they provided unless they're going to give it to us during the course of this trial. It'll be the first time I've heard it. And you're not going to hear anything during the course of their conversations about any argument. In fact, again, I keep saying it, assuming the state gets it proved in, Jay Lee makes a comment, makes that he sins. If this goes bad, it's not going to be good for you. I'm going to read that. And again, assuming it gets that far. Now, let's talk a little bit about what the state's required to prove and what I don't think their evidence is going to show. Proof of the death. First of all. Proof of any death whatsoever. 0. DNA evidence, blood, urine, trace evidence whatsoever. With counsel opposite told you that we don't have a body, not only do they not have a body, ladies and gentlemen, they don't have one scintilla. That means anything in legal terms. First of all, that a death occurred in Lafayette County if it did occur. Second of all, any trace evidence in his apartment by their own proof that they say they're going to put on, and went over there twice, apparently engaged in sexual activity on 2 separate occasions, according to their proof. 0. I'm not saying speculatively, it is their proof that a crime was ever committed inside our client's apartment, or in the parking lot, or in his car, or in JD's car. Nowhere. I remember yesterday in council, Mr. Creekmore, I've known a long time, he said, ladies and gentlemen, we think we're going to have a gamut of opportunities for you to find Mr. Herrington guilty of murder, manslaughter. What they're expecting you to do is to allow them to throw something up against the wall, hope it sticks, and you decide, hey, that's the proof you're going to hear. Objection. Argument. Ladies and gentlemen, you are not going to hear anything that supports a finding of a killing or a death. Period. You're going to hear some conversations between 2 young guys. Like I told y'all yesterday, I got 7 kids. These kids nowadays send stuff back and forth to each other. That's what happened here. You're not going to find anything supporting whatsoever that inside his apartment anything untoward occurred. And finally, and probably most importantly, I want you to listen to a lot of the things during the course of this investigation that didn't occur. I'm going to say it now, and I'm going to repeat myself. 22,000 documents we've had provided and discovered, 7 law enforcement agencies, 71 search warrants. 71. And if they're going to be honest with you during the course of this presentation, when Miss Lee came up here and came to the University Police Department, they covered their whole department. Everybody got involved in this investigation. The police department then got involved in it. They inquired with the FBI, Grenada County Sheriff's Department. 71 search warrants and they have it recovered, not one bit of direct evidence to support this case. And I challenge the prosecution and the Oxford Police Department, Ryan Baker, nice fella, Jamie Portman, nice fella, challenge them to say we have one bit of direct evidence. You can't go on conjecture, you can't go on speculation, you can't go on suspicion. Guesswork, wonderment, all those things you can't do. It's got to be factual. And I submit to you, ladies and gentlemen, this conversation or this search that she made reference to about strangling, we don't have any idea what the context of that may have been about. And they're not going to be establishing the context. That could have been something that my client was talking about, some sexual activity with a lady, or even Jay Lee. Who knows? Someone else. Or not else. But you're not going to find that he ever acted any evidence in that apartment. He acted in any way, shape, form, or fashion. I submit to you, ladies and gentlemen, that at the conclusion of this case, you're going to have just as many questions then as you do right now about whether or not they've proven the death. You will, in my opinion, and I submit to you, you will not be satisfied if they establish that. Only the verdict you can return is going to be not guilty. Not the manslaughter, not the second degree, not the murder, certainly not the capital murder, or any of them. And that's what I'm going to ask you to do. Thank you very much.
Ladies and gentlemen, the jury, before we call our first witness, I got just one little short matter I got to take care of. Y'all will return to the jury room. Don't get calm. We're not going to be there long anyway. Somebody find what rat's in the attic and get rid of it anyway. I don't know what's going on up there, but get that stopped anyway.